Due Process, winner of 25 regional Emmy Awards, including the 2014 New York Emmys for our coverage of criminal justice and current affairs. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
It's all been burglary, robbery.
That's it.
No violence.
No violence.
No assault.
No assault.
Kevin Polk 16 years ago, and Kevin Polk now.
They got murderers, actual people that killed people got less time to me, and that bothers me when I think about that.
Because sentenced under the 94 three strikes law, Polk must serve 35 years, be 70 years old, before he can even be considered for parole. 3 strikes and you can be in for life on this edition of Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding from the New Jersey State Bar Foundation and the PSEG Foundation, making things better in our communities.
It was triggered by the kidnapped murder of a 12-year-old California girl, abducted from her bedroom by an ex-offender with a long, violent criminal record. The cry was, keep them locked up. The result, tough laws like 3 strikes, first in California, then in 25 more states, including New Jersey. I'm Sandra King, and the idea was to save us all from the worst of the worst, the most vicious and violent repeat felons. But too often it hasn't worked that way, as we found out nearly 16 years ago when we first met Kevin Polk in Trenton State Prison.
My record says that I'm not a vicious, violent felon because I don't have any vicious, violent crimes.
A small-time crook with no record of violence against anyone.
Burglary, robbery. It's all been burglary, robbery.
That's it.
No violence.
No violence.
No assault.
No assault.
But Kevin Polk, who had then been in for 2 years, was facing life in this maximum security prison.
How you doing, Miss King?
My God, 16 years.
Yeah, it's a long time.
All these years later, he is still locked up, and he'll be here for nearly 18 years more before he has even a shot at parole.
They got child molesters get less time than me. They got murderers, actual people that killed people got less time than me, and that bothers me when I think about that.
Not that Polk had been a model citizen. He had a propensity for robbing convenience stores, and in his last crime, a bank. In each case, though, his weapon was a toy gun. But in New Jersey, the law says that's the same as if he'd walked in with an Uzi.
Our law says that a robbery is theft or attempted theft with force or the threat of force. And a first-degree robbery is when that happens with a weapon or a simulated weapon. So that could be a toy gun, that could be 2 fingers on the inside of your jacket.
I've had access to guns, and you know what I mean, but I've always chosen to use a toy. My intention is not to hurt nobody.
And if he had opted to use the real thing, shot or even killed someone, his sentence would likely have been the same, maybe even less harsh.
So why not bring the Uzi and maybe shoot someone?
That's exactly the logic that opponents of 3 strikes laws have put forth. That's exactly why judges should be vested with discretion in sentencing. We should empower judges to make a distinction between someone who pulls a real gun and someone who pulls a toy gun.
But restricting the discretion of supposedly lenient judges is what mandatory sentencing's all about. That's how laws like 3 strikes got passed in the first place.
The legislature's intention in enacting this legislation was to protect the public from persons who persistently commit serious and violent crimes.
That was the sentencing of the first three strikes defendant, a violent criminal named Gregory Oliver.
He has done nothing else in his life but hurt people, victimize people, and that simply has to come to an end.
And though Oliver, who died in prison, Polk, and not too many others have been sentenced to 3 strikes, the law has been widely used in another way.
Here's how. The state doesn't have a strong case, but they tell the person either you plead and get a couple of years in prison, but if you lose at trial, the judge will have no choice but to send you away for life without parole.
And according to Alex Shalom, a public defender before joining the ACLU, the plea offer can sometimes be as low as probation.
Whenever you go to trial, we acknowledge that there's a risk you'll do worse. But this law converts a gamble into Russian roulette. You go from looking at probation to looking at life. There's something simply unfair about that.
The state will move to dismiss all remaining counts.
But while 3 strikes is often used to leverage plea deals, Kevin Polk never had the choice.
They never offered me no deal.
No deal?
No deal. From the door, no deal. Burlington County did not offer me any deal.
He says he would have taken the deal, though a plea bargain is what landed him that life sentence.
In New Jersey, the predicate crimes have to be first-degree crimes, which carry a term of between 10 and 20 years.
When I went to the courtroom, the prosecutor stood up and said that we're seeking 3 strikes for this gentleman.
Polk's second strike came from an attempted convenience store holdup 2 decades ago. Aborted, he says, when the clerk, who realized the gun was a toy, refused to hand over any money. Polk accepted a first-degree plea, but now insists it was not a first-degree crime. And he's pinning his hopes on what he says was an incorrect offer and sentence.
I can show for a fact that that crime was not a first-degree crime, and it wasn't even a robbery. No robbery was committed. Nothing was taken.
But it's a long shot.
Frankly, it's long ago now, and these sorts of collateral attacks on convictions are difficult to bring. It doesn't mean he doesn't have a claim. It's just, it's certainly no slam dunk.
Still, Polk insists that he, like so many of the men housed here, deserves another chance.
They made mistakes like I made mistakes. They made bad choices like I made bad choices.
You've paid an enormous price for those bad actions. Think about it a lot?
Every day. Every day. Every day.
Well, Kevin Polk's still hoping for the miracle that might free him. More likely, he'll spend the rest of his life locked up, and all because of a largely forgotten law that remains on the books here in New Jersey. A law that's been applied here more as a threat, an incentive to plead, than an actual sentencing tool. So is it time to overturn 3 strikes as another draconian, tough-on-crime law that never accomplished what it was supposed to? We're likely to get 2 very different answers from Jennifer Soletti, a deputy public defender in Middlesex who has worked on problems in corrections, and Bob Bianchi, former Morris County prosecutor, now in private practice. Welcome to you both. And let me start by asking you, Jennifer, to put Kevin Polk's story in the context of those times when laws were getting stiffer, sentences longer, everyone panicked about crime.
And the 3 strikes law clearly is a creature of all of the tough-on-crime laws that we saw being enacted in the 1990s. And what we're seeing across the country now is pulling back those laws because of the problem of mass incarceration. Stories like his we see over and over again, whether it be 3 strikes or whether it be other mandatory sentencing laws that put people in prison for vastly longer sentences than they would receive under the ordinary statutes or being convicted for the ordinary crimes. And as Alex Shalom from the ACLU said in the piece in the introduction, it takes away the discretion from judges to look at the individual circumstances of a crime and make the punishment fit the crime.
Circumstances like using a toy gun?
Absolutely.
Or not getting any money because somebody recognized that it was a toy gun?
Absolutely. I think that says it perfectly. Using a toy gun is different than using an Uzi. It's different than using
But not according
a
to
loaded
New Jersey
gun.
law, Bob.
No, absolutely. The threatened use of a weapon, whether it's a toy gun or not is an element of force to the other person, and it is a first-degree crime. And the judge doesn't have discretion to call it something different than that. So if you want to amend that law to say, well, if it's a real gun, it's one crime, but if it's not a real gun, it's a different crime, then do that. But the law right now is that if you threaten the use of a weapon during the course of a robbery or threaten the use of force, it becomes a first-degree robbery, and that's a violent crime.
Does it make any difference that, as we understand it, the woman who was behind the counter in the convenience store said, hey, my kid's got a gun like that. I'm not giving you any money, and didn't give him any money, and he left?
That may make a difference in the discretion of a prosecutor if this were an isolated case. But what I heard on that video clip is a person who has a career of committing burglaries, robberies, a bank robbery, a store robbery. So if it were an individual case, and when I was the county prosecutor and it wasn't a toy gun, I may look at that a little bit differently. But when you look at the overall mosaic of this man's criminal history, a prosecutor has the obligation to deter conduct and to make sure that there's not going to be further victimization of people down the road. And it speaks to me of a picture, a mosaic of a person who is continuing to be involved in first-degree violent crimes. And that's what this law was meant to eradicate, those people.
This law, Bob says it made sense, and it still makes sense.
I don't think it makes sense. And one of the major reasons I don't think it makes sense is because of one of the issues that Bob just alluded to, which is discretion, prosecutorial discretion. To use these kinds of laws and to charge people with these offenses in an effort to give them really no other choice but to plead guilty to crimes. It is sort of akin to if you go into a store and there's a dress that's on sale, a dress that costs $200, and the store marks it up to $400 and sells it to you for $300 and tells you you got a deal. And that's what happens in these cases. The prosecutors will charge someone with a 3 strikes offense, say, we'll amend it, but we'll give you a maximum sentence or give you a much higher sentence than they might get if they were to go to trial on a traditional charge.
So that's the whole entire plea bargaining process to begin with. But let's not forget certain realities, Sandy, in my opinion, about this. The fact of the matter is, they're not saying he's not saying I didn't do it.
No.
The prosecutor isn't saying plead guilty to something you didn't do. The prosecutor is recognizing that you can't bring every case into the criminal justice system, and plea bargaining is we've actually had a show on, is a very essential part of the process. The defendant gets a little, the prosecution gets a little, and you meet somewhere in the middle. But it's not like the prosecutor saying plead guilty to something you didn't do. That's his choice. Go to trial.
But if you didn't have a 3 strikes law, then you wouldn't be in a position to demand, say, on the first or on the 3rd strike, this guy wasn't offered a deal, but usually they are offered deals. And the deals are much tougher than they would have been if it were, in fact, each crime being considered separately, not having a 3 strikes law. Is that fair that somebody who might have gone to prison for 2 or 3 years for each of those crimes, instead for the 3 crimes, goes for life without parole?
If I had to answer this question, if we could step out of our lawyer roles for a minute and look at the real world, and then you have to jump into the prosecutorial world and handle cases and protect the community, you're not talking about a person that committed a singular act. This 3-strike law requires, essentially, that you have been convicted on 2 or more occasions of very violent crimes.
And you've served time for those crimes.
And you may have served time for those crimes.
In most cases, you've served some small amount of time.
Right.
Now you've got a 3rd strike that's essentially the same crime as you've been committing
or
previously, and here you're looking at life without parole.
Yeah,
That's
to get
so
life
huge.
without parole, those crimes, though, have to be murder, aggravated manslaughter, 1st-degree kidnapping, sexual assault, rape, 1st-degree robbery, which is the use of force, or carjacking.
1st-degree robbery, a convenience store with a toy gun.
Yeah, but
How would that, if you were sitting as the prosecutor?
Right.
I mean, while the judge loses discretion in these kinds of laws, the prosecutor gains. So it's the prosecutor's call whether or not to go for 3 strikes. It's not automatic on the prosecutor's side.
Right, and what I'm looking at is, forget the toy gun piece, I'm looking at the other instances of conduct that he got involved in and the offense for which he is charged now. And what I don't want as a prosecutor is to give the defendant, to treat him, would it be fair to treat him just like somebody who committed their 1st crime and didn't commit 2 previous crimes and then a 3rd very serious offense? I don't think that's fair.
I'm going to ask Jen to answer that question.
But an elimination of the 3 strikes law wouldn't create that, because of course a judge is always free to consider the person, their background, their offenses, their prior offenses, in determining an appropriate sentence.
But not required.
But not required.
Yeah, but
and so on a first-degree offense, their sentencing ranges anywhere from 10 to 20 years in state prison. Somebody with a prior record and somebody with a track record of some of these other offenses would get closer to a 20 versus somebody who might be it might be their first offense and they would get a 10, but they wouldn't get a life
Well,
sentence.
not necessarily. And we know that a lot of this reaction to these laws that have passed were because there were some judges that found, and I had this happen as a prosecutor, where we believed the state prison sentence was appropriate, and the judge on a non-mandatory sentence went below that. So one of the reasons with this discretion that judges had, the legislature wanted to put into place an escalation system so that if you are involved in more serious offenses and you continue to get re-involved in violent crimes, then your sentence is going to be enhanced with the idea that you're no longer going to victimize the community. I think that that's completely appropriate.
So you don't think it's a problem to take the discretion away from the judge with all these mandatory sentences?
I do, actually, I don't want to sound contradictory here. I do have a problem with a lot, and so do many prosecutors, with all of the mandatory sentences that we have that go far beyond this. This one is dealing with very violent crime, the most violent crimes that we have in our criminal code. But there are hundreds of other crimes. It seems to us, and in fact we were talking about this offset, that every time something happens, a politician stands up to be tough on crime, passes a mandatory sentence for a first offender, and for those people who are showing efforts for rehabilitation, which I think is a major role of the prosecutor, those people who we believe would not represent a continuing danger to the community, we were remorseful that our hands were tied with mandatory sentencing on less serious crimes than this. But this is different. These are the biggies. These are the biggest.
And you
of the
consider Kevin Paulk's crime to be in league with rape and murder and
well, I mean, we can't
and violence. I mean, I can certainly understand his frustration when there's no record of him ever having committed any violent act.
And the reality is that he's doing more time than somebody who has been convicted of a murder or a kidnapping or a similar offense.
Well, I'm not sure of that, and I think that if we start comparing cases, are there disparities that occur in sentencing? We were talking about this as well. Unfortunately, the philosophy of law in the prosecution world is sometimes askew. Each county handles things and prioritizes things different. But if you're convicted of a murder, at least when I was prosecutor in Morris County, you didn't get a plea deal. We didn't plead murders to manslaughter, ag manslaughter. If it was a murder, it was a murder. And if you didn't want to plead guilty to it, we went to trial, and you got 30-year to life sentences because that's under that crime.
You didn't get life without parole.
But if you had committed previous offenses and you showed a continuing pattern of violent criminal activity, your sentence would be enhanced. That's the reason for this law.
Let's talk about California, where this all began, and where most of us heard about 3 strikes the first time, when you started hearing about people stealing pizzas or toilet paper, and that being the 3rd strike, because California said, okay, 2 serious crimes, and then anything for the 3rd crime. That's been reversed. But isn't that sort of the natural extension when you start second-guessing and trying to show how strong you are on crime, that you can get to the point where California got, which put tens of thousands of people in jeopardy?
Well, actually, I think New Jersey was contemplating that when they were originally passing this one
That's
back
true.
and forth. And that, to me, would be an abhorrent abuse of a law, and I agree with that, because if you're a person who winds up stealing a roll of toilet paper after 2 crimes, that's a de minimis offense. It's not something that represents a continuing danger or actual violent victimization of another person. So I look at that completely different, and that's why this law eventually was passed, that it has to be a victim violent crime. Our gentleman from the prison over here can sit there and say the words, I was never convicted of a violent crime, but I heard bank robbery, store robberies, burglary, which I personally think is when you go into somebody's home. I don't know what kind of burglary it was. I don't know if he was armed or not. But these are very, very serious victim offenses.
So if you were writing the law, would you make a distinction between the toy gun and the Uzi?
No, I don't make the distinction, because to the person that's on the other end of that, now in this particular case, you're going to say, well, the person knew it was a toy gun. But if somebody goes in with something that appears to be a weapon, they're going in with that for a reason, in order to communicate to the victim, give me your money or physical harm will come to you, you will get shot. To me, there's no difference if the person is holding a real gun or a toy gun, if the person on the other end of that feels that they're in danger of being killed.
But is there a disincentive then to using the toy gun? I mean, if you're in the business of doing these things, Are you throwing in a disincentive? I might as well use a real gun and shoot somebody if I have to.
Well, I don't know if somebody would think it through that way, but I think one of the
Kevin says that he absolutely had access to guns and never used one because A, he didn't want to hurt anybody, but B, he didn't want to go to jail for a long time.
Well, and one of the things that is interesting is if we're talking about this, we're talking about what he was going through his mind at the time. We're talking about what was going through the mind of the clerk as they're looking down the end of the toy gun and realizing, hey, that's a toy gun, is that we're considering the individual circumstances of the people involved in making a decision about whether or not it's fair in this case. And that's all we're asking for judges to be able to do, is to be able to not make it a mandatory sentence, but to be able to consider that, to consider the state of mind of both the defendant and the victim when this crime took place in deciding maybe this doesn't warrant a sentence of life. Maybe it warrants a lesser sentence, but because of the way the law is written, it's sorry, it's your third strike and you're in.
Bob, you did not try any 3 strikes cases? You didn't bring any 3 strikes cases?
I don't believe so.
So why not? If you like this law, surely you had people who came before you with 3 strikes.
Yeah, I mean, I honestly, until you asked me that question, I can't say for certainty, but I don't remember any cases. The cases that we had, typically speaking, the ordinary sentencing code was, in our opinion, fine enough to sentence a person, and that's where a prosecutor does have discretion. Hopefully the prosecutors being appointed have skills, wisdom, background, and you can look at various cases, and that's one of the safety valves.
And you didn't tell your folks, look out for multiple offenses so that we can bring a 3 strikes.
No, and that's the safety valve to this whole thing, is the prosecutor does have discretion. I know people don't like discretion, but they don't like discretion, and then when there is no discretion, they want no discretion. When there is no discretion, then they want discretion. But I wasn't looking to hammer people to go into prison simply to put them in for as many years as possible. Find the guy, let's dot I's, cross T's, look for that particular person, let's put him in jail for as long as we humanly can. We went after the cases based upon the facts of the case, the law of the case, and the seriousness of the offense. And Morris County was known as having some of the highest plea offers and convictions in the entire state, so it wasn't like we were soft on crime.
Okay, so we've got 3 minutes left. I can't believe how quickly this has gone. But let me ask you, we've been talking about the application of the 3 strikes, but in fact, it's not something that in New Jersey has caused a lot of convictions based on trials where somebody had a mandatory sentence of 3 strikes and you're in for life. Instead, how's it used?
It has not caused a lot of convictions, but has caused an awful lot of pleas. The threat of being charged with a 3 strikes offense, pre-indictment by a prosecutor who may say, if you don't take this plea, I'm going to indict you under the 3 strikes law. All of these mandatory sentences are forcing people to plead guilty even when their cases are very strong cases to take to trial, because the risks of going to trial on some of these cases are just too high.
And as you said when we began, those offers tend to be higher because there is the cudgel of 3 strikes?
Absolutely.
And I say this, I agree with some of the lower level mandatory sentencing that we have is out of control, but not with respect to this law. And I ask people to use their common sense when they're thinking about this. Everybody has a strong opinion about defendants' rights, and I got no problem. I'm a defense attorney, okay? I fight for my clients very hard until it's your family member that's been robbed, or your family member that's been raped, or your family member that's been murdered, or there's an aggravated manslaughter, or one of these horrendous crimes. And then you're going to want to know, why was it that this person was allowed to get out, go to prison, get back out, go to prison, and continue to victimize people? You got to use common sense. These people have demonstrated they are not worthy to continue to be in society based upon their prior record and having either committed a murder, ag man, kidnapping afterwards.
Okay, you've both noted that there is more of a will, seemingly, today to do away with mandatory sentencing, at least some of it. But it seems to me mostly the focus is on drug crime. And there's a lot of crime that falls under mandatory that's not drug crime.
Absolutely.
The will, it seems to me, at least in a bipartisan way, isn't there.
I think it's going to change, and it's going to have to change because of the alarming prison population rates at this point. We have right now 1 in every 31 people is under some sort of supervision of the criminal justice system in this country. We are incarcerating people at such a high rate. I read today that in the Department of Corrections of New Jersey alone, 74% of people are serving mandatory minimum sentences of one kind or another.
A problem?
Oh, absolutely. I think that we've been putting people in jail like cordwood. Nothing was worse than the 1,000-foot law, the 500-foot law, especially if you were from the inner city. You were getting mandatory sentences. I, as a prosecutor, would break my heart sometimes to see some people going to jail for some of these offenses. So on the lower level crimes, I agree. We need to stop political grandstanding, and we need to start giving people reasonable sentences on the low level stuff.
And it breaks my heart that we're out of time. With my thanks to Bob Bianchi and Jennifer Saletti. I'm afraid we do have to stop there, but it's a conversation that will continue here at Due Process, where our focus is always on questions of law and justice. So we hope you'll join us next week and every week. Till then, for Raymond, who had this one off, and producer Tanya Bentley, I'm Sandra King. Thanks for watching.
It's really the culmination of years of saying, you know, we need to have harsher sentences, and the way we're going to fix crime is by locking more people up and locking them up for longer. And we've flipped our whole sentencing scheme on its head. It's disproportionate to the crimes. People are starting to recognize that we lock up too many people in this country, right? That any country with 5% of the world's population shouldn't have a quarter of the world's prisoners.
So have we gotten any better since Kevin Paulk was sentenced 20 years ago?
In many ways, we've gotten worse. There's some marginal gains we've made, and we've also made some, there are lots of places we've slipped. We're going to get to a place where we recalibrate our sentencing system, among many other reforms in the criminal justice system.
Wishful thinking?
Probably, but could be both wishful and correct.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.